Hey, bankruptcy colleagues, Jim Selbach here. Today's bankruptcy case involves the issue of disclaimers, and that is if a debt collector or a creditor sends your client a demand for payment after the bankruptcy is filed or after discharge, but they put a bankruptcy disclaimer somewhere in the document, is that going to relieve them of all liability? Well, the issue is pretty clear, and Judge Davis of the Northern District has just written a decision in which he kind of reaffirms that. So I want to talk about that for just a couple of minutes. Now, this seems to be a change for Judge Davis because in previous cases, it seemed like if there was a disclaimer anywhere in the document, no matter where it was, no matter how big the font was, it seemed the court said, no liability, motion dismissed. Well, this case seems to change that view and goes along with what every case that I've seen rules. So let's take a look at this case. It's in re Sharack. It was a Chapter 13 bankruptcy case involving Bayview Loan Servicing. Now these guys we've dealt with on a number of occasions, and they're repeat violators. And what happens is you put your client in a bankruptcy, whether it's a 7 or a 13, the client wants to just surrender the property, they move out, and they had listed the original mortgage holder. Subsequent to discharge, usually, this mortgage itself, or sometimes just the servicing, is sold to companies like Bayview. And these guys want nothing to do with the stay, the discharge. They're just trying to get their loan modification through, and they're continually bombarding these people with demands for payments, statements, loan modification applications, which the debtor never asked for. And they don't much care about the stay or the discharge. They're repeat violators, and Bayview is one of them. This case was a discharge injunction violation, as I said, to Chapter 13. Bayview acquired the mortgage after the discharge. The stay was lifted by the original creditor, but Bayview continued to send statements. These were regular mortgage statements. You owe X amount of dollars, you are in default, late payments, the whole 9 yards. Now, these statements included, and this is what the court brought up, a total amount that they claimed was due, and that's usually on the top. You owe $139,000. Once the debtor sees that, they're on the phone with you. Well, what's going on here? I thought I didn't know this, but they're telling me I owe $139,000. A notice of late fees, it's a regular mortgage statement. The due date, your payment must be received by us by a certain date. Sometimes there's a payment coupon listed in there, or included in there rather. And these are the factors that Judge Davis looked at in deciding whether there was going to be a violation here. Now, Bayview, as all these companies argue, this is for informational purposes only. This is to comply with the truth in lending law. What's a bunch of crap? If the client has surrendered the property, they don't even live in the property anymore most of the time, what possible need would they have for any information about this mortgage? If there's a foreclosure and there isn't enough recovered, obviously the deficiency has been discharged. So they don't care what the numbers are. So this argument that, we're just sending this for informational purposes is really a dodge. The real purpose is trying to get some of these people to pay. So the court finds in this case that this was an attempt to coerce or harass the debtor to pay. This was not for informational purposes. Then it gets on to the disclaimers issues, and this is where it becomes interesting. What's a disclaimer? Well, here's what one looks like. You've probably seen them. It's in there someplace. To the extent your obligation has been discharged, blah, blah, blah. This is for informational purposes only. It does not constitute demand for payment. A lot of times it's buried at the bottom or on the second page or on the back in small font. But that's the disclaimer. Now, I wouldn't say some. I would say Judge Davis was the only case that I've ever seen where it says if that disclaimer is anywhere in the document, you're all done. Motion denied. And we've had cases that we brought in front of her in which she did exactly that. So we were kind of surprised when we got the Sharack decision. The real rule is disclaimers sometimes provide immunity from liability, depending on a lot of factors here. What are those factors? Well, she pointed to the fact that there was a coupon book included. She alluded, as I said before, that there was a demand for payment. She talked about the position of the disclaimer. Now, a lot of these disclaimers, the statement at the top in very large font, you owe whatever. And then somewhere else in very small font is this disclaimer. Well, that's important because it doesn't bring to the attention of the debtor that there's some kind of informational purpose for this document. The only thing they say is you owe $139,000. So for the first time, Judge Davis did what all the other courts did, which is to say, if it's up front, if it's in the same font or larger font, maybe you're going to get immunity from any kind of liability. But if it's buried somewhere, if it's small font, that's going to be a factor for the court to say, that's not an effective disclaimer. The font size, we talked about that. Now, a lot of our clients, when we ask them, did you see this disclaimer? A lot of them didn't. You know why? Because they look at the first thing that they see as a demand for payment. And they don't go looking for the disclaimer. They stop reading at that point and they get on the phone with you guys. So if you have any of these cases involving loan servicers who are demanding payment, sending statements to your clients after discharge, and if they include disclaimers, pay attention to where that disclaimer is, what kind of font it is, what the font is used for the demand for payment, which is usually much larger than the other portions of the document, including the disclaimer. So if you have any of these cases, if you have any questions, you'd like to refer them to us, I'd be happy to talk to you.